Good morning, everyone, and welcome back to our weekly webinar series. Today, we are taking a very good topic. We're talking about voluntary liquidation, and of course, there are multiple processes available today to shut down a company, but voluntary liquidation under IBC is one of the most used processes. So let's understand the nitty-gritties of the same, and also understand various judgments and case laws on the same.
Thank you, Ankit. Welcome to 108th episode of AAA Weekly Webinar Series. As Ankit has already told, that we will be discussing the briefly other modes of closing a company, shutting a company down. Ankit will also support on the other methods. Voluntary liquidation, as introduced by Insolvency and Bankruptcy Code, is the main mode of shutting a company, and we will look into the practical aspects and also judicial pronouncements on this. So, Ankit, can you actually say something about this, the kind of various other means of closing a company, like in case we have to say something like maybe striking off the company under Section 248 of the Companies Act, or dormant status of the company.
The dormant status does not basically liquidate the company, or doesn't finish the company, or doesn't rather dissolve the company. Dormant status only keeps it in a dormant status, where some filings are exempted for a dormant status company. It is like somebody can create a company and say that, okay, this is not in use presently. Company does not have any active business, and therefore they can report a dormant status for that company to MCA for 2 or 3 years. And that's the periodicity for the dormant status. The strike off that is available, as you shared, that strike off is available once the company does not have any business for 2 years, number one. Number two, the company should not be having any pending litigation. And thirdly, the company should not be an insolvent company. It should be where there is no asset, no liability kind of situation.
And do you think this, some people even they close a company by merging 3 or 4 companies together? So that also is a way of closing some of the companies by just merging it with another company.
Yeah, so merger would of course put an end to the transfer companies in case there are any company which has maybe more liabilities than the assets. The group wants to, does not want insolvency for that company. It can, easily try and see, in case the creditors and the stakeholders agree for all the companies, they can merge the companies. But there the problem can be that the stakeholders or shareholders of the company which is having a positive net worth may not be willing to merge their company into a negative net worth company. So it has to be a very closely held company to, have that.
So I think our focus today is to discuss on this voluntary winding up or voluntary liquidation. When we say, basically what we are trying to say is that this is the process where the company in fact self-imposes its own liquidation and dissolution after approval of the shareholders. So this was earlier found in Section 484 of the Companies Act 1956, and then now it is found in Section 270 of the Companies Act 2013. But like with effect from 1st April 2017, when this Section 159 was notified, Section 59 of the IBC was notified, along with the regulations, which is called IBBI Voluntary Liquidation Regulations, and that actually came in force on 1st April 2017. So that was the main time when this was notified, and then later on, even the transfer of pending proceeding rules 2016 was also kind of brought into force. That was Rule 4 of the transfer of pending proceedings rules 2016, that was also brought into force by a notification dated 7th December 2016, which is effective from 1st April 2017. And in fact, that was stipulating that all applications and petitions relating to voluntary winding up of companies pending before any High Court prior to 1st April 2017 shall continue to be dealt with by the High Court as per the provisions of the Companies Act 1956 or 2013. Any fresh voluntary winding up effective 1st April 27 shall only be introduced before NCLT under the provisions of IBC code and regulations made therein. Then MCA issued a notification on 29th of June 2017 where the transfer of proceedings relating to cases of voluntary winding up to NCLT. So with that notification, it was mentioned in that notification that all proceedings of voluntary liquidation of a company where the notice of the resolution by the advertisement has been given either under Section 485 of the Companies Act, but the company has not been dissolved before the 1st April 2017, the liquidator shall make an application for dissolution directly before the Honorable NCLT. So this load was taken from High Court and it was given to NCLT. Now, the companies are supposed to be liquidated in certain circumstances. It can be the accomplishment of purpose for which it was incorporated. It can be even a clause mentioned in the article when 2 or 3 people collectively incorporate a company and then their purpose is resolved. The company is unable to carry its business, or it's not viable, or it's not making profit. The operations are not feasible, and also kind of the promoters and the department, there is nobody to look after this company, or there is no successor to that company. So therefore, this Section 59 of the IBC was there in the so that is to handle the voluntary liquidation. Then the Section 35 to Section 53 of the liquidation process, that is also applicable to voluntary liquidations. Then Section 68 to Section 77A, that is the offenses and penalties, that is also applicable to voluntary winding up. And then the regulations made with effect from 1st April 2017 are also there. So the regulations are like 40, from 1 regulation to 40 regulations. So let us say Section 159, what it says. In fact, Section 59 deals entirely with the voluntary liquidation. It says that, first of all, that corporate person can actually intend to liquidate itself voluntarily in case it has not committed any default. Then only it can initiate the voluntary liquidation. That's what the basic condition of the voluntary liquidation, that the corporate debtor is solvent, it can pay all its debt, no haircut is sought, and there is no pending litigation. And if there is a pending litigation, before even dissolving the company, it has fully been provided for. So that kind of situation, that the voluntary liquidation can be started. So how it starts? The voluntary liquidation starts with a declaration from the majority of the directors verified by an affidavit. And what that declaration will say, that they have made a full inquiry into the affairs of the company. Then they have formed an opinion that the company has no debt, or if the debts are there, then the company will be able to pay all its debts. And the company will not seek any kind of waiver or any kind of relief. And then the company is not being liquidated to defraud any person. Such declaration is required. That is the first thing. And it is also required to be submitted to ROC in the e-form called GNL2. So that is the first step in voluntary liquidation. Now, the declaration that is supposed to be made by the majority of the directors, that should also have the audited financial statements for the last 2 years, record of the business operations of the company for the last 2 years, or for the period in case the company is recently incorporated, for even since the incorporation of the company, and a report on the valuation of the assets of the company, if any prepared by a registered valuer. That is something which has to be the initiation. So like in case we say the what is the stages of the insolvency voluntary liquidation, the first step is convene a board meeting and submission of a declaration to ROC along with the attachments. Second step is within 4 weeks of the declaration, a special resolution has to be passed by the company in a meeting of the shareholders, and then in that meeting the liquidator would be appointed. Then in case there are creditors, then approval of the creditors holding 2/3 value of the total debt of the company in case of pending debt, that also is required. And then intimation to ROC and IBBI within 7 days of the resolution of creditors, that is step number 4. And then upon approval of the liquidation proceedings, again the company deemed to be commenced, that is the date of such resolution. And then the IP is appointed as the liquidator of the company. So then the process starts. So this is when we say this special resolution, which is supposed to be passed by the majority of the shareholders of the company, that resolution also will be filed before ROC in an e-form called MGT 14. So this is the process first. For this is a stage 1. So in case we have completed this, and then the second stage is like giving a public announcement and also intimating the assessing officer under section 178 of the Income Tax Act within 30 days of the appointment of the liquidator, so that the income tax department should also get alert in case they have to file a claim or in case they have to complete some of the assessments. That also can be immediately informed to them. Then the next step would be the voluntary liquidator will file a preliminary report within 45 days. Then the public announcement, which actually will give 30 days time to all the claimants to file their claims, and then the claims will be verified by the liquidator, and the liquidator is also given 30 days time. Then the liquidator will prepare a list of stakeholders within 45 days. Then the liquidator will open a bank account, which is called liquidation bank account of the company. Then the liquidator will start realizing the assets and distribution of the assets to the creditors. And then the submission of the final report to ROC and IBBI, and then an application to the adjudicating authority, that is NCLT, seeking the dissolution of the company. And once the order of the dissolution is passed, then the adjudicating authority, means NCLT order, that will have to be submitted to ROC within 14 days of the receipt of the order. Now, let us understand what is the effect of the voluntary liquidation whenever it starts. It actually, what is the impact? So the first impact is that the company will cease to carry its business. However, there is a provision that in case the liquidator feels that some business has to be continued for beneficial winding up of the liquidation of the business, that means there is a concept of keeping the company as a going concern even during the voluntary liquidation. As we see that there is a concept of keeping the company as a going concern in the liquidation process, similarly, there is a process of keeping the company as a going concern in voluntary liquidation. Even if the liquidation is started, the company continues, the company exists till the time it is dissolved. The basic difference between the normal liquidation, where the company is under stress or the company has defaulted, and voluntary liquidation, the very big difference is that the powers of the board of directors, powers of the key managerial personnel, that does not get completely suspended. So their powers may continue. Their power to resolve may continue wherever it is required. So this power of board of directors and the powers of the key managerial personnel, in fact, continues in this voluntary liquidation process, and they have the power to monitor the process, and also they have the power to even approve and even to decide on the mode and manner of the sale of the properties. That is what they have the power to monitor, regulate, and also to oversee. Then the liquidator also has significant powers because the liquidator has been appointed and he has liquidation the complete powers so that the management does not influence and the interest of the shareholders and the interest of the creditors are protected. That also is very, very important because the main role in the voluntary liquidation is to protect the interest of the shareholders who are not a part of the management. The liquidator is responsible that whenever the assets of the company is being sold, that assets must recover complete money and it is distributed to creditors first and then to shareholders in an appropriate manner. That's the basic responsibility of the liquidator in voluntary liquidation cases. All the compliances of the law has to be met. All the taxes are supposed to be paid. The TDS has to be applicable. The GST has to be applicable during this process, and the liquidator is responsible for this. And the liquidator cannot take any advantage of as the other part of the liquidation. The company will continue to have books of account. The company will continue to have complete monitoring of the assets and liabilities. So this is the basic concept. Like although when we say that the powers of the board of directors are there, we also feel that the powers of the liquidator is also kind of very high. These are the legal powers, these are moral powers. The liquidator is entrusted with significant duties to see that the management, that means the board of directors, they are not doing anything which is impacting the interest of other shareholders. So that's what is the moral duty and also a legal duty of the liquidator. See, who actually would be appointed as the liquidator and who would appoint. So basically, the resolution of the board members shall actually be appointing the terms and conditions of the appointment, the fixation of remuneration. That will be decided by the board of directors by way of a resolution. And then the insolvency professional who is appointed as a liquidator, within 3 days, he has to inform the IBBI about his appointment. Then it like has to be independent from the corporate debtor. It should not be a related party. And the remuneration also shall form part of the liquidation cost. And the regulation 6 now says that the liquidator can also be changed. The liquidator can also be changed by way of a resolution passed under section 59, subsection 3 and clause C. A liquidator can also be changed. Then the liquidator shall prepare a kind of report which will be submitted to the adjudicating authority under regulation 8, and that report is preliminary report, and then the other report that is supposed to be prepared is the annual status report in case the liquidation continues beyond 12 months. Then while applying for the extension, the liquidator is also supposed to file the annual status report, then the minutes of the consultation of the minutes of the consultation with the stakeholders and final report. When the liquidator prepares preliminary report, the regulation 9 very clearly says that the report has to be prepared within 45 days of the liquidation commencement date. It should also have the capital structure and of the corporate person, estimates of the assets and liabilities, intention to make any further inquiry into any matter relating to the corporate person, and proposed plan of action, timelines, estimated cost, how the asset will be sold, how it will be distributed. All that will be part of the preliminary report. The liquidator, like although the market fees are very low, but in the voluntary liquidation, the job of the liquidator is still tough because the liquidator is also supposed to make many registers, books of accounts, and there are in fact 12 registers that the liquidator is supposed to make as the liquidator of a trust company. Liquidator has to keep all the receipts and payment accounts of all the receipts and payment. But then the liquidator is not supposed to make the but in voluntary liquidation, if the company is working as a going concern, then the liquidator is also supposed to make financial statements, also required to file income tax returns, and also required to pay income tax if any income is earned by the company during, even while the company is in liquidation process. So that's a very basic difference. The liquidator can engage professionals wherever it is required, and it is some, like maybe for any kind of GST, TDS, income tax, any company law, the liquidator has the powers. But all these professionals, probably the stakeholders will have the consultation, and the board of directors will also have say in appointment, because see, the liquidation cost has to be borne by the company, and the board of directors are still having the power. The board of directors and the shareholders are still having the power to replace the liquidator. So the liquidator cannot kind of engage professionals without the consent of the stakeholders or even the board of directors. One that we see, like as far as this transactional avoidance transactions are concerned, it is very clear that the Section 59 says that the Section 43 would be applicable, Section 45 would be applicable, 49 would be applicable, Section 50 would be applicable. So, but then Section 66 doesn't seem to be applicable in the case of voluntary liquidations. However, the first of all, the condition is that there is no default, the company is solvent, and the company will make payment of all the liabilities, and the company will not have any litigation, and all the litigations are closed or provided for. These are the first conditions for dissolving a company. So therefore, as far as Section 66 is concerned, that may not be in fact relevant for voluntary liquidation. However, preferential transaction is applicable, undervalued transactions are applicable, and Section 49, which is the undervalued transaction with the intent to keep the property of the company away from the creditors, and that intentional part, that is Section 49, that is also applicable. When the liquidator makes a public announcement, the public announcement has to be made within 5 days, and the claims are supposed to be submitted within 30 days. And then this is in one case where, in fact, in one of the case of Mr. 𝐝𝐤𝐬𝐜𝐬, who is an insolvency professional, and the IBBI, in fact, the disciplinary committee of the IBBI reprimanded by way of a penalty of ₹1 lakh to 𝐝𝐤𝐬𝐜𝐬 only because he did not release the public announcement for receiving the claims, and even there was a delay of 18 months. So the observation of IBBI was that this is a larger kind of lapse, so therefore the penalty of 1 lakh was imposed. So the public announcement has to be made by the voluntary liquidator within 5 days of the start of the commencement of the liquidation. The liquidator has normal powers, as normally all the liquidators have. So that kind of powers are there: verify claims, taking control and custody of the assets, evaluation of the assets, and to protection and preservation of the assets, and to carry on the business of the company in case it is required for the beneficial liquidation, like the company can be kept as a going concern also during liquidation, to sell all the movable, immovable properties and to distribute the proceeds, and also to kind of control the bank accounts of the company, and also become the signatory in all the bank accounts of the company. So every power of the liquidator, normal liquidator, and the liquidator for voluntary liquidation companies are basically similar. Now, the only a question that it was raised amongst many people, that can liquidator file application for non-cooperation during voluntary liquidation process? So the answer is yes, because any personnel of the corporate data, or maybe its promoter or any director, in case any assistance is required, or any cooperation is required, or any information sharing or is required, and is not assisting or not cooperating, then an application can be made to adjudicating authority. for necessary directions under section 34 subsection 3, read with section 19 subsection 2 of the code. So this is yes, the liquidator has the power. Then the filing of the claim is a normal process. The claims will be filed by the workman, Form B, then Form C for the financial creditors, Form D, and then the Form E. So, like in this case, even the claims are supposed to be filed by the shareholders also. The security interest also would be provided, and that will be verified by the liquidator. Then the claim substantiation part, it is similar to other verification in the liquidation process. So the contingent claims and the foreign currency claims, periodic payment claims, all this is mentioned in the regulations, and that is all similar to the liquidation process regulations and voluntary liquidation process regulations. So, like when we talk about, there is a question which is very, very like kind of after the Airtel judgment, the question of setting off. Although there is a regulation which is Regulation 28 of voluntary liquidation regulations, the mutual dealings between the CD and other party can be set off, and net amount can be claimed. And I think the indication was received in Swiss Ribbon case, where the Honorable Supreme Court has observed, while writing the judgment of Swiss Ribbon, that the set-off may be considered at the stage of filing of the proof of debt while initiating the resolution process by a resolution professional. Then the another case which was like decided by in the name of Vijay Kumar versus Bharti Airtel, and the in this Vijay Kumar case, the concept of set-off was explained as equivalent to making a preferential payment over the other operational creditors. No dues can be recovered from corporate debtor when moratorium period under Section 14 is in force. And while deciding the disputes on counterclaims or set-off, NCLAT requires the determination of the following: whether there was mutuality between the parties or not, whether the set-off was done before the initiation of the CIRP process. So these two conditions were mentioned in this Vijay Kumar versus Bharti Airtel case. So that is applicable to the voluntary liquidations as well. So in case of deviation from any of the requisites which is mentioned in this case of Vijay Kumar versus Bharti Airtel, then the courts have a right to say that the set-off was invalid and that set-off is not possible. Verification would be done by the liquidator in 30 days from the date of receipt of claims, and admittance or rejection after verification is the result. And in case of rejection, the liquidator has to give a reasoned order, and then it is considered as appropriate. So there is a case in the name of Indian Oil Corporation Limited versus Ashish Arjun Kumar Rathi, and this corporate debtor in this case is the SBQ Steel Private Limited, and the judgment is from NCLAT Delhi, and it is the Ashish Arjun Kumar Rathi is the liquidator. So in this case, the NCLT and the NCLAT held that not assigning reasons for rejecting a claim is not a prudent and reasonable course of action. Then the second thing that this court held, that and in respect of interest, merely stated that as per the contractual agreement there was no provision for an interest and hence not considered are incorrect and illegally untenable in the eyes of law. So the interest can be even awarded by the courts, NCLT or NCLAT. At this moment, Ankit, can we see some of the questions, if we have the questions?
Yes, so we can take them up one by one. One question is that if there is an income tax litigation which is pending and the company is under appeal, can company file for voluntary liquidation? So in case there is a demand which is fought against by the company in the appeal, then that demand is an outstanding demand. However, if the company has paid that demand and it is still filed an appeal, then also it will be considered as a pending litigation, in my opinion. So they
See,
can still go for waiving.
according to my understanding, and there is a judgment also, there are two circumstances. One, that there is no demand outstanding. However, there is a income tax refund which is outstanding, but that assessment is also pending. So then the NCLT has already passed an order that since the return was filed, it is a case of refund due. So when the dissolution application is made, so the corporate debtor has the right to even ignore the refund part and still go for the dissolution of the company. So that is the, like, even along with the refund, even there was an assessment here. Assessment was also pending. So the assessment is pending, no claim from the income tax department. So that was held as a kind of compliance, and the company was allowed to be dissolved. However, as the question says that in case the appeal is pending before Commissioner of Income Tax, then it is possible to dissolve a company if that particular demand is provided for. If that demand is completely reserved somewhere, that in case that demand will finalize, then it will be uh, paid. So that is also one of the options available.
Then question that is there any requirement to obtain NOC from income tax? I don't think so.
Now, even IBBI has given a judgment, a circular in 2020. I believe that some of the RPs are going for taking circulars from the income tax department, NOC from the income tax department, which is not required. So it was directed to insolvency professionals that they should not apply for this NOC from the income tax department. Yes.
Then there is a question that can any potential receivable be assigned to shareholders and in which ratio? I think it has to be equally between equal stakeholders. Then the second question is that can some shareholders be paid less amount and then pay them on receipt of funds after some time? I think equitable distribution is a requirement.
Equitable distribution is the requirement, and it is not possible that in case you have 100 shareholders and you only distribute to 50 and the rest of the 50 can wait. No, whatever you are distributing, you have to divide by 100 so that everyone gets that particular part of the payment.
Then, if liquidator closes bank account, where will money be deposited upon receipt? So the account needs to be closed when all the monies have been received. I don't think there's a requirement to close the account before that. So that's how it
As
should
I
be.
said,
And
that there
also the
is reason in the regulation that any kind of asset can be assigned to someone. So that assignment is possible. And once it is assigned, then the assignment information will also be given to the pair. So the pair will pay to the assigner, then the pair will not pay to the company directly. So that will be assigner. I mean, that can be even the liquidator, and which the liquidator understand where to distribute and how to distribute this part of money, which will be received from the corporate debtor.
if the claim is not filed within 30 days before liquidator, what are the remedies for the creditor?
So it is actually held in some of the cases. The NCLAT has given a judgment that in one of the cases, the one person, like the company was dissolved and 45 lakhs of claim he actually uh, could not file on time. So RP rejected. So adjudicating also authority also rejected that in case you are not able to file your claim, then we are not going to protect. Then NCLAT in fact protected that person, and only for a unique reason, because the person actually had sent an email to the corporate debtor, and in that email he actually said that about this payment, and then the NCLT says that this particular judgment may not be used anywhere. As a special case, I am allowing the appeal, and since the uh, like that's the, but like I would say, the NCLAT says that uh, it was a special case, and because of that email, it was sent back to adjudicating authority. But otherwise, it is held in many other cases that if the claim is not filed, the company is dissolved, then thereafter the claimant will not have any right.
Then Mr. Anil Raj Kutia, he says, as per the new, he has two questions. He says, one, if TDS on fixed deposit has been deposited and by the rather pending to be received as a refund. Number two, in case there are certain litigations which are pending where the client has chances of the decision coming in the favor of CD. Then he says that the dissolution petition cannot be filed in the within the timelines. So we understand that these are good reasons for one or for a liquidator or for a voluntary liquidator to say that I need to extend the timelines because of these reasons. This is what we understand.
Yes, but then considering the market dynamics, the normally people are kind of fixing a fee for the liquidator as a lump sum. So liquidator would like to dissolve the company as fast as possible. So he has the powers to say that yes, he can provide for a litigation, and he can find out a mechanism where the litigation would also be continued and it will be attended, but the company can be dissolved. So in case such situations are possible, then NCLT will pass an order that so and so will look after these litigations, and if the result will come, that result will be handled in this manner. So that kind of possibilities are there, because it is also mentioned in some regulations. I will just come to that after the questions.
Then Mr. Ranjan says if is MC and CB and other statutory filing necessary. So in case the company is under voluntary liquidation, MCA filings would not be required because the company is not making any balance sheet during the process. What is your opinion on this?
So in case the company is earning profit, the company is definitely going to pay income tax on that. So there is no waiver from the income tax department, unlike the other liquidation processes are concerned. In case the company has fixed deposits or shares and the company is getting some dividend or some profit and capital gain, that capital gain is also taxable. So once we have everything, I think for filing an income tax return, you need to have the financial statements. In some cases, even the tax audit will be applicable. So my understanding is that during liquidation process also, a liquidator is supposed to make books of account. And if there are 1 or 2 or 3 years or the continuing process is there, then the even auditing would also be required. Income tax also has to be paid. And if there is any refund, that also has to be claimed. So that's what is my opinion.
Then we are saying during voluntary liquidation, whether it is compulsory for liquidator to close all the other banking accounts and transfer the funds to the bank account opened for the purpose of voluntary liquidation. So
Sorry,
I
Ankit, I couldn't understand this question even.
the so if the company has, let's say, three accounts and you start voluntary
Which account?
liquidation, three bank accounts. Let's say the company has three bank accounts as
Okay.
on the commencement of voluntary liquidation, and if the company opens then a voluntary liquidation account under the liquidator's control, and then is it a mandatory requirement to close all the other banking accounts? I think the idea is to make sure that the funds that go out in any way or get distributed should be distributed through the voluntary liquidation account, because practically many receipts that come in are coming into accounts which are already put in somewhere. Income tax filing also sometimes you're putting in the accounts, but is it a requirement to shut down all the other accounts?
No, see, the question is, one is the liquidation process. In the liquidation process, the liquidator has the capacity to take control and custody of all the assets. Bank account is also an asset. Taking control and custody and the operations powers definitely will come to the liquidator, and the board of directors will not have any power to operate the bank account. So if there are existing three accounts, the liquidator can operate one and get the other two closed. But in case there are transactions which are regularly coming to other two accounts also, then the liquidator can run all the three accounts in case the time permits. But once the company is dissolved, then the NCLT will say that before we pass the order of dissolution,
You have to close all the accounts.
you bring to us that you have
Closure
already closed
certificate,
all the
yeah.
accounts. And if there is any provision to be required for any future transaction, that we can also earmark that this is one is given to so and so person, or it is earmarked to use and spend in future. That is also possible.
Whether minority shareholders have any say in voluntary liquidation process, I believe the general shareholders resolution is what is required there. Minority shareholders anyways have the Protection of Companies Act in case they feel that the majority shareholders or the management of the company are doing something with intention. They can always file a complaint, with the NCLT or file an application before NCLT on the using their minority status. I think uh, that's the solution available here to
Yes, that's
minority
right.
shareholders.
That you're right. Yes, absolutely.
Can the voluntary liquidator resign?
See now, since there is a power to replace, and I believe the liquidator can also resign subject to NCLT approval. Because now we can see the liquidator can also like kind of resign subject to NCLT approval. That's the only thing that I can say.
If there are any delays in NCLT approval, what would be the compliances and who would bear the cost? I think the time cost will be borne by the liquidator, and if there is any other cost, then that has to be borne by the assets of the company. Several cases where the assets of the company may not be available. There again, I believe that the stakeholders then have to comply with whatever contribution in the cost, if any. But it all depends on what kind of agreement and what kind of fee has been agreed for the whole process. Normally, the trend is to have a fixed fee for the entire process, and therefore it is very, very important to do a proper due diligence on how much work will be involved in the process that a liquidator is taking up. Then Raviji is asking, in the process of opening of new account and obtaining closure certificate, banks are asking letters from directors. I think we need to show some judgments. We need to explain the law. There are so many banks in the country. Not everyone can understand IBC law. But yes, that's what I think needs to be done here. With the order in hand, one has to take it up.
Yes.
If any liability arises after dissolution, who will be responsible? Can the dissolution?
Nobody would be responsible.
Yeah, because somebody did not file a claim. Yeah.
Unless it is proved that this company has been closed with the defrauding intent.
Defrauding intent, or some claim has been missed, something has not been done as per process.
Yes.
I think that's about it. Then, if it is mandatory for the liquidator to form an opinion under section 43 and 45 of IBC, even in case there is no liability.
Yes, Ankit. What is this question again?
43 and 45, does the voluntary liquidator has to file the
Yes, in case as I already said that in case there is any transaction under section 43, 45, and 49. However, section 66 is not applicable under a voluntary liquidation. 43, 45, and 49 is applicable. Section 63 is outside the reach of voluntary liquidator.
So a lot of more questions. We have 30 more questions. There are a lot of questions. So, but we can resume, and maybe we can take these offline.
Yes. So then we also have, as I said, that's Regulation 29 says that the creditor whose claim has been rejected will have a right to appeal within 14 days of the rejection order. And there is a judgment from NCLAT on this. That judgment name is Harish Khurana, liquidator of TEIL Projects Limited versus Engineers India Limited. So in this case, the rejection and admission is been held as the power of the liquidator, and section 42 provides for remedy of appeal against the decision of the liquidator. Therefore, the appeal is maintainable. That's what is held by NCLT. So the liquidator is also supposed to prepare a list of stakeholders within 45 days of the commencement of voluntary liquidation, and the list will be even filed before the adjudicating authority also, and how the list has been accessible, whether the list is accessible, that advertisement also, a public announcement has also to be done. Again, in case I would like in the other liquidation cases, in case there is any modification in the list of stakeholders, that also will have to go again to NCLT. And the liquidator, of course, has the power to modify the list of stakeholders. And the list of stakeholders is actually very important, that it should be available for inspection by the persons, by all the claimants, and also available for inspection by members, partners, directors, and guarantors of the corporate debtor. And it will be displayed on the website of the corporate debtor and also website of the IBBI. So the manner of sale, the liquidator has to sell and decide about the manner of sales, but it is also supposed to be approved by the corporate person. Like the company also has to approve how the assets will be sold. Similarly, the recovery of the money is due, like the sundry debtors, receivables, that also the liquidator has to recover all this in a time-bound manner to only maximize the realizations for the stakeholders. Then in case there is any uncalled capital, unpaid capital contribution, like in case of party paid shares, the liquidator has the right to invite the capital, and use it for the payment of creditors. That is a contribution which is kind of required, like, because the party paid shares, and first of all, fully paid and partly paid has to be brought together, and then that money has to be used for payment of creditors. And if there is still a money left, which then that will be distributed to the shareholders. So in case somebody is not bringing any uncalled capital, unpaid capital, then if later on any distribution is required to be made to the shareholder, that person would not be entitled who is not giving the contribution of unpaid capital or partly paid capital. See, bank account has to be opened by the liquidator, and all these transactions has to be through the bank account. The distribution has to be done within 6 months from the receipt of to the stakeholders. That is also one of the conditions. And if an asset is not realizable very quickly, so even the liquidator has the power to even allocate or distribute that asset to some of the claimants, but that is subject to the powers, that is subject to the approval of the company in their meeting. So any distribution which is done little high or not appropriate, later on decided that money can come back from at the request of the liquidator. Completion is provided in Regulation 37. It is provided that within 12 months it has to be completed. However, in case it is not completed within 12 months, then the liquidator shall hold a meeting of the contributories within 15 days, and then it will be again every successive meetings, the 12 months, that kind of meeting will happen, because there are voluntary liquidation cases which are actually continuing for the last 3-4 years. So after every 12 months, such meeting will take place, and such decision to again continue the liquidation process will be taken. However, in every meeting, the status report, annual status report, would be submitted, and final report is provided in Regulation 38, that actually will go to Honorable NCLT also, to the Registrar of Companies also, to IBBI also. The final report actually will have this audited accounts of the receipt and payment audited accounts. That also would be there in the final report, and statement where the liquidator will demonstrate how the assets are sold and how the distribution was made, and on the realization of various current assets and cost of realization and the manner and mode, that will be the final report. and after the final report is submitted, then NCLT will pass the order where this will be a company will be dissolved. So then, like there is a regulation 40 which actually says that in case it is detected by the liquidator that the voluntary liquidation process has been initiated to defraud a person, then the liquidator has the power to make an application to adjudicating authority, that means NCLT, to suspend the process of liquidation because he has found the fraudulent intention, and he has seen maybe misappropriation of the assets, and then presentation of the false valuation of the assets, dishonoring the existing contracts, undervaluing the or overvaluing the assets, then saving sister companies. So these kind of in these kind of observations by the liquidator, and that actually can suspend the process of liquidation in case the liquidator finds that, and an application can be made to adjudicating authority. Similar to the liquidation, the liquidator is also supposed to keep the records of the company for 8 years. That is also required to be maintained. So as we say that since the prerequisite for any voluntary liquidation is that the company actually has no debt or is in a position to pay its debt, and the company is not being liquidated to defraud any person, and if there is a debt, 2/3 of the creditors in value, they have approved this process of voluntary liquidation. Finally, the regulation 38 says that the main ingredient for voluntary liquidation is that there should be no pending litigation, and the debt of the creditor should be discharged to the satisfaction. And in fact, there was a judgment from NCLT Kolkata in the case of Central Inland Water Transport Corporation Limited, where the liquidator in fact filed an application for suspension of voluntary liquidation on the ground of pending litigation, and the claims against the corporate debtor exceeded the value of assets. So in this case, the liquidator said that there are several litigations pending, and there is a misrepresentation about the value of the assets, and the total claims which has come that exceeds the value of the assets of the company. So therefore, the NCLT Kolkata passed an order where the voluntary liquidation was suspended. And there is also a kind of possibility that the withdrawal of the voluntary liquidation is also possible in case any fresh opportunity for the business comes, or the management of the company thinks that the decision for voluntary liquidation was bad. So therefore, the court can decide that this voluntary liquidation can be withdrawn at the request of the stakeholders. That means the board of directors and the shareholders. So there are similarly various judgments. So Ankit, we can take some of the questions in case there are. I wanted to in fact say that the IBBI issued a circular on 15th of November 2021, where it was directed that the liquidator will not be required to seek any NOC or no due certificate from Income Tax Department. So these are like a case was also there in NCLT Delhi in the case of Kansal Hosiery Export Limited, where it was one refund was not received. That means that the refund is not received, and that assessment is also pending. However, everything else was considered to be okay, and the court in fact held in this case that the court say that we have seen that the company is not being liquidated to defraud anyone. We have also seen all the necessary compliances of Section 59, and an affidavit has also been placed on record there where all the assets have been liquidated and distribution. So in view of all this, we are satisfied that the company can be closed. Just pendency of one assessment order and pendency of one refund. That assessment actually may lead to kind of more demand, but then it was held that that one assessment is pending, that cannot be a reason for not dissolving the company. So it was decided to dissolve the company. So, Ankit, I think we can take up some of the questions.
So one question is with respect to valuation, role of valuation of assets in voluntary liquidation. So I understand that the valuation of assets in case of voluntary liquidation happens before the voluntary liquidation process is started, because whatever assets are sitting in the balance sheet of the company need to be valued, and that valuation report is used by NCLT when the voluntary liquidation application reaches them. So that's the process there. So here,
Yes, if it is required, and
if there is any assets, in case there is a land and building asset in the company, then that will be required. In case there is a SFA, so that's of course needs to be taken care of. And this is a process that is not done by the liquidator, by the voluntary liquidator, but it is done by the company or the consultants helping the company with the process. So
yes,
those are the professionals who can assign the valuation work.
right.
Then a question is that if a company is wound up and a separate puff order is passed by NCLT against directors, what will be the status of claim against the directors?
No, I don't think it is a question of directors, because see, when we say that this section 59 subsection 6 says, Ankit, that this section 35 to section 53 is applicable on voluntary liquidation processes, but not section 66. So when we see section 43 preferential transactions, the preferential transactions are applicable to creditors who actually have taken some money in preference. Then in section 45 also we see that some section 45, in case something has been transferred, and that is irrespective of the director or not director, if something
Undervalued
transferred,
transaction, yeah.
undervalued transaction. So
Mm.
section 66 is only for the directors, but that is not applicable to voluntary liquidation cases. So like in case any director is involved in preferential transaction, that is separate. If any director is involved in such an undervalued transaction, that is separate. But the fraudulent uh, uh, trading and fraudulent intent, where the contribution is required from the directors, that is not applicable in voluntary liquidation cases. So wherever any undervalued transaction or any preferential transactions are there, those cases will continue.
Then, of course, there's a very important question that what kind of ITR is required to be filed for companies under liquidation. So, it would be important for everyone to understand that the income tax return provides for a special clause for companies under liquidation where they're not required to report their profit and loss balance sheet. They are only required to report their receipts and payments. And that's the process that liquidators can follow for companies which are under liquidation, wherever balance sheet and ITR is, not prepared.
Yes.
Then we have a question that says that can the
See, like
liquidator...
even Ankit, even regulation 44, sub-regulation 1,
Hmm.
I think this is the liquidation regulations, but not voluntary liquidation. But then in regulation 38 of voluntary liquidation regulations, it says, on completion of the liquidation process, the liquidator shall prepare the final report consisting of: one, that no litigation is pending against the corporate person or sufficient provision has been made to meet the obligations arising from any pending litigations. So that is also possible. So even if the avoidance transaction is pending and there is a assignment or there is a person made responsible, that whosoever will pursue these transactions application, and there is an agreement that he will continue to enforce these litigations and to follow up these litigation, and whatever the result would be, he will distribute in such manner. But still, I feel that the money will be received. If the money is received in the name of the company, then it is difficult to dissolve the company. And that is something that the courts will have to decide, but then it is not so far has been seen. Uh, Let us see what happens in future. But according to my understanding, no litigation is a report that has to be submitted by the liquidator.
Then we have a question that can the liquidator allocate NRRA without the approval of NCLT or with approval of NCLT?
So I think the NRRA process in case they approve, and then it can go to NCLT along with the final report. And in the final report, it can also be approved accordingly.
So in case there is, let's say there is a bank and the bank had filed a recovery case before a civil court for recovering the amount, and then however the bank did not while that process was ongoing, the bank did not file the claim before the liquidator. So is it possible to file a delayed claim there?
I think once the litigation is pending and there is a declaration has to be made by the directors, majority of the directors, that no litigation is pending. So the directors must be knowing that there is a pending.
So for voluntary liquidation, this will be completely, the bank can use the pending litigation to say that the voluntary liquidation was totally illegal.
Absolutely.
But in case of a normal liquidation, there what will be the process? In case, let's say this is not
normal liquidation, they will file their claim even if their litigation is pending before DRT.
So if they forget to file the claim, they can file the claim and then try to seek the liquidator.
In case the in a normal in a like a liquidation of a stressed company, if any claim is not filed, so there are various provisions where the belated claims can be filed. Even if the belated claims are not filed and the company is finally dissolved, then thereafter there is no possibility of claiming it from anywhere.
But while the liquidation is going on, the bank can perhaps file a delayed claim through that process, or rather, try to establish in case the bank's loan was visible in some financial statements through which the liquidator would have known about the loan. So all these things can be taken care of. Yeah. I think I've taken up pretty much all the questions that were available. Moratorium, is there any moratorium available in voluntary liquidation? No, there is no moratorium per se.
Nothing like moratorium, because once the voluntary liquidation, like everyone can sue the company and the company can sue any other person. Moratorium is not available.
Is summary liquidation different from voluntary liquidation? Summary liquidation. Don't know about summary liquidation. I think is a process for strike off.
He's talking about the striking off.
Strike off is called summary liquidation. So strike off, of course, you file a form with the ROC, and the ROC takes some time, but then finally processes it. Yeah, right. 6 months time or whatever they take. I think lots of more questions, but I think we have a limitation. There's still 41 pending questions which I could not take up. So a lot of response from our participants on this subject, and I believe that what we can do is we can always ask our participants to share these offline with us, and maybe we can then try and answer these.
Right.
Thank you, everyone.
Thank you very much. Today, I am attending a CII event at Kolkata, so I now have to speak at that event. So I asked them to keep my session a little later. So there's a lot of people gathered here at Kolkata, and it is an event on IBC. And since we have a commitment of getting connected with you at 11 a.m., so I just skipped that event for 1 hour and again going back there. Nothing else. It's like our way of learning. Thank you very much.
Thank you, everyone. Thank you so much for joining us today. Thank you.